Hi, my name is Diane Wanger, and I am a Texas board-certified family lawyer. Today, I am talking about whether, as a Texas resident, you should have a living trust. People call my office about estate planning, and they tell me that they learned about living trusts on the internet or from a relative, and they want one. They are certain that it will make the transfer of their assets cheaper and easier, but more important, that it will avoid state-imposed estate taxes. It is true that in many states, estate taxes can be avoided by having your assets placed into a living trust. California is an example. To be sure, many wealthy people have or should have a living trust. And by wealthy, I am talking about people whose assets, including life insurance, exceed the ballpark area of $11 million or more at the current 2020 federal estate tax exemption level. If you are in that category, this video is not meant for you. A living trust declaration creates a special legal entity called a trust. The trust can own assets, including investments, real estate, and most other things that an individual can own. The trust is managed by the person or company designated in the document as the trustee, usually you. The trust defines the people allowed to benefit from the trust, usually you, and the terms of the use of those assets. When you or your spouse die, the trust provides for a replacement trustee, and the trust will define the successor beneficiaries of the assets as you and your spouse die. The trustee of the trust has full authority to deal with the assets. That is why, upon your death, if all of your assets normally subject to probate are in a trust, probate might not be necessary. There are other ways to avoid probate I talk about in my videos, Ways to Avoid Probate and Transfer on Death Deeds. Links to those videos are included below. A living trust also can provide privacy impossible without a trust. Although there are advantages to a living trust, I rarely suggest them for my clients. You say, "But Diane, why not?" The problem is this: it is expensive to create a living trust. You have to transfer all of your assets into the trust. That act requires more expense, and you will still need a will to operate if the trust is not properly funded, or if you acquire assets outside of the trust. These requirements are detailed, and failure to follow them properly can defeat the whole purpose of creating the trust. I can tell you, from 35 plus years of experience, it is not the nature of an average person to be as detail-oriented as required to gain maximum benefit from a living trust. Using a living trust to avoid estate taxes is not a valid concern unless you are extremely wealthy. However, if you have assets in other states, like real estate, or you move frequently, there may be more benefit to a trust. In Texas, and that is the only state that I am speaking of, the probate process for a properly executed will is neither expensive, nor is it time-consuming. You also need not worry about state-imposed estate taxes because there is a federal estate tax credit for 100% of any state-imposed estate tax. Again, my name is Diane Wanger. I help people statewide for estate planning. If you would like my help, call 817-285-2855 or email to Diane@familylawtex.com.